Good afternoon. My name is John Payton, and I am your Justice of the Peace in Precinct 3, Place 2. If you are with the McKinney Independent School District, this video is being made for you to help you better understand and provide information on the new parent contributing to non-attendance and the new charge of truant conduct for students in the state of Texas. I am coming to you today to discuss the new changes across the board in the truancy laws that have been passed by the legislature. First, I'd like to talk about the parent contributing charge. There are a lot of misnomers and sadly a lot of rumors that parents are no longer held responsible or that their cases have been expunged. That is not the case. A parent contributing to truancy case has not been expunged, and all cases prior to September 1st, 2015 still exist, and the court costs and fines, if they've been assessed, will still be owed. With that being said, Section 25.093 of the Family or the Education Code is still in circulation. That has not changed. So the requirement for a parent to require their child to attend school between the ages of 6 and 19 are still in place. Now, under the new law, the age to require a student to be in school has changed. It is now 12 to 19 versus the student being only required to be in school through their 18th birthday. And I'll make more of a note of that when we talk about the new truant conduct cases. However, on the parent contributing cases, it is important to understand that you as the parent is still charged with a criminal offense. It is no longer classified as a Class C misdemeanor, but now is just a generic misdemeanor charge. Before, a parent could be charged with a $500 fine plus court costs. Now that has become a graduated process. So for every charge that a parent is charged with parent contributing to truancy or your child failing to attend school, you can now be fined for the first charge, $100, the second charge, $200, the third charge, $300, the fourth charge, $400, and the fifth charge, $500. Every charge thereafter would be a $500 fine. Every day that your student is not in school and it is not excused and it is considered to be truancy and falls under Section 25.093 is a date that can be charged for truancy. The previous law stated that a parent could be charged with truancy if there were 3 unexcused absences or parts of days in a 4-week period of time. That was a discretionary filing. That is no longer in existence. That has changed. The school district now, if there are 10 days of unexcused absences or parts of days absences in a 6-month period of time, the parent can be charged with truancy or parent contributing to truancy. If this does happen, then every day that is after the 10th day deemed unexcused or a part of a day unexcused could constitute a separate charge. If there are 2 or more charges, the charges can be consolidated and prosecuted in the same prosecution versus having separate trials. However, you would begin, if you are found guilty of the charge of parent contributing to truancy, you would be fined accordingly to the progressive fine chart that has been given to you earlier. And then again, after the 5th charge, if there's charge 6, 7, 8, 9, and so forth, you're looking at a $500 fine plus court costs that can be assessed against a parent. That's not all that's changed. Now, a parent, if the court determines is not doing their job or not representing the child well, can order a guardian ad litem to be ordered to your case. If this is ordered, the cost, if it is found that you can pay for it, then is passed on to you. I have been told by our district court here in Collin County that the minimum time that a guardian ad litem will put into a case is 15 hours. By state law, the fee that is charged is $100 per hour. So a parent potentially could be looking at an additional cost of up to $1,500 on top of whatever fine and court costs could be assessed as well. Furthermore, a parent, if the court determines is still not representing the child or the guardian ad litem is not representing the child well, can hire an attorney to represent the child in the proceedings. Again, once it's determined that you can pay for the cost, and that determination is not based on what your bills are versus what your income is, but it is based solely on what is determined to be an indigent defendant. If you are not deemed indigent, then you would have to pay those costs. Again, I am told that if an attorney is appointed in such a matter, the bill could easily get up to between $1,500 and $2,000. So on a maximum scale, the fines and fees that could be affiliated with a parent contributing to non-school attendance has, I would say, gone up dramatically because of the fact that a guardian ad litem can now be assigned and have to give you basically advice and possibly walk into your home and do a home visit to try and dissect whether or not you're really providing a good, strong family environment for your child. And with an attorney now being appointed and you having to pay for the cost of that, that also adds the additional cost. The court order for a parent will still fall under Article 45.051 of the Texas Code of Criminal Procedure. That is a deferred adjudication. Now, a lot of folks will kind of goof up the name. It's not deferred adjudication. It's not deferred adjudication. It is deferred adjudication. And what that means is the court is willing to take your plea of guilty or no contest. No contest meaning you're not admitting to guilt, but you're going to be found guilty by the court, and deferring it, setting it aside, and putting you under certain conditions. Those certain conditions could be that you provide service for a charitable organization. The court can now order that you do community service for up to 50 hours of community service with your child. Under the deferred, the court can order psychological testing, drug testing. The court can order drug counseling. The court can order drug treatment. The court can order regular counseling if a child or parent is struggling through that process. So your deferred becomes a wide open opportunity for the court to issue conditions that the court feels would be in the best interest of the family to encourage good attendance through you for your child. Furthermore, the parent has also come under additional scrutiny under the new law under Section 65, Title 3 of the Family Code. The court can now order you to pay for services that the court determines to be in the best interest of both you and your child, whether that be parenting classes, whether it be counseling, whether it be drug treatment, inpatient, outpatient, or drug education classes, and can order that you pay for those classes. The court can now hold you also in direct contempt of the court. They can exercise a fine of an additional $100, or 3 days in jail, or community service, or all three, depending on the form of contempt. And again, this is all just for the parent. Comparatively, in the old law, if you didn't follow your court order, the only time that you could be looked at to be held in contempt is if you were not attending a class for at-risk youth. So now, however, you can be looked at for direct contempt of court, looking at a $100 fine, up to 3 days in jail, or up to 40 hours of community service, or all three. So as a parent, I encourage you, and as a parent of a child of my own, I encourage you to work with the school, work with the counselors at the school, work with your individual counselor, or seek out assistance through other means. I have had police departments refer students and parents to me to seek out advice on other programs that may be able to prevent some of this truancy. The idea is not to punish you. The idea is to really get into what's going on, identify it, and then help provide a solution so that there's not a problem where you end up in court. And so if you can come to the school and talk with school officials, whether it be the counselor, the assistant principal, whether it be the crisis counselor on campus, then that would give you an opportunity to start looking at resources to hopefully prevent your trip into the courtroom. Because coming into the courtroom is neither fun nor is it inexpensive. Furthermore, if you have any questions in regards to the new laws, you can go online to the Texas Legislature and look up House Bill 2398. 2398 explains all of the different requirements that a student has to go through, which I will cover here shortly in my next segment. There is also the requirement of truancy prevention measures that have been imposed upon student cases. I mention this here in your video because you need to be a part of those truancy prevention measures. Once your student hits 3 unexcused absences or parts of days in a 4-week period of time, the school district must hold a behavior intervention plan meeting. When they hold this BIP, They are going to go over their truancy prevention measures with you and your child. They're going to attempt to contact you by phone, possibly by email, or even by mail to set up this meeting. The school district must make a good faith effort to make this happen. So they are going to note on their referral and on their BIP whether or not you were able to respond or not. It would not look good if you were not able to respond and refuse to attend a meeting where they're trying to assist you in staying out of court. So you want to make sure that you attend this behavioral intervention plan meeting so that you can place your child under a BIP with truancy prevention measures so that your student can find success and hopefully avoid the courtroom, again, at all costs. If your student, though, again, hits 10 days in a 6-month period of time that are unexcused or parts of days that are unexcused, then they may refer you to the truancy court so long as in their truancy prevention measures they have told you that they would refer you to the truancy court. The requirements for the warning notice haven't changed. You should see a warning notice when you first sign up for school for the beginning of the school year. Most of those are done electronically. I do believe that all the school districts here in Collin County have an electronic format for you to review the handbook and sign off on the handbook. The warning notice is in those handbooks. Then they still must send you another warning notice. My guess is going to be that when you attend that behavioral intervention plan meeting, that is when you're going to receive your second warning notice, letting you know that if you're not careful and you get to 10 days in a 6-month period of time, that you could be filed on for parent contributing to your student's non-attendance. And so those rules haven't changed whatsoever. If a parent decides that they want to pull their student out of school for a trip or vacation, all of the school districts in Collin County have a school district policy that's been passed by their board that vacations during the school year will not be counted as excused absences. Under Section 25.087 of the Education Code, that is where excused absences are defined. And I will read for you. A district shall excuse a student from attending school for the following purposes, including travel for those purposes: observing religious holy days, attending a required court appearance, appearing at a governmental office to complete paperwork required in connection with the student's application for United States citizenship, or taking part in a United States naturalization oath ceremony, or a temporary absence resulting from a healthcare professional if that student commences classes or returns to school on the same day of the appointment. Under Section 25.087, there is nowhere where a holiday or a traveling vacation is excused. The school districts in Collin County have passed a policy where they will not excuse absences if your student goes on vacation or a holiday. Furthermore, under Section 25.086 of the Education Code, that is where all of the exemptions exist for your child to be exempt from school attendance. In there, you're not going to find where a holiday or a vacation or travel is excused, and so therefore the school districts in Collin County have all passed board policies where they will not excuse those style of absences. If your child has more than 1 day of absence, it is not truly an excused absence, it's an exempt absence under Section 25.086. And I'm going to read this to you specifically because this comes up quite a bit in our conversations in court. A child is exempt from the requirements of compulsory school attendance if the child has a physical or mental condition of a temporary and remedial nature that makes the child's attendance infeasible and holds a certificate from a qualified physician specifying the temporary condition, indicating the treatment prescribed to remedy the temporary condition, and covering the anticipated period of the child's absence from school for the purposes of receiving and recuperating from that remedial treatment. That is the exemption. So if your student has the flu, if your student has a virus that keeps them out for multiple days, then you have to get with your qualified physician to go ahead and provide you with a certificate diagramming all of the things that I've just read to you. And again, you can find that on Section 25.086 under the exemptions of the statute. When you come into truancy court as a parent, there are a few things that have changed. One, you will now have to sign off on a waiver of rights, indicating that you understand what you're signing and understanding what you're waiving. Some of those rights will be that you have the right to an attorney, but you do not have the right to a court-appointed attorney. Some of the other rights may be that you have a right to a jury trial. These are rights you have already signed off on in previous years if you've had to come to court. However, now it will be spelled out in a waiver of rights. Also, the court will have to notify you of your right to appeal. We will do this as well at the end of your order being entered or at the beginning of your order being entered to notify you of what your right to appeal is. When we go through those rights, you will then sign off on a waiver of rights saying that you've understood them and you've decided to waive those rights, or you can say you have not, and we can push forward into a jury trial. For a parent, you're still going to enter a plea of guilty, not guilty, or no contest. No contest means you're not admitting to guilt, but you're going to be found guilty by the court. Guilty, of course, means guilty, and not guilty, of course, means not guilty. If you choose to take this to trial, you will meet with a Collin County District Attorney or a city prosecutor. At that point in time, you can then discuss what your options are in full with those prosecutors. The court cannot discuss with you in full what your options may or may not be in regards to trying to plea bargain or your discussion of not guilt, because the state would not be present or the city prosecutor would not be present. So what you have when you come to court the first time is kind of like a pre-trial that we call it. You come in, we explain to you the charge, we explain to you your waiver of rights, your right to appeal, we explain the process of what's going on, and then at that time you enter a plea. If you enter a plea of guilty, we push forward, no reason to set a formal hearing at that time, and we issue your deferred adjudication and we go forward. If not, then you can enter a plea of not guilty and take it to trial, and at that point we then go to a formal trial process. Furthermore, there seems to be quite a bit of confusion in regards to the minimum attendance for class credit. This is called the makeup hours that your child must have to be able to get credit to go to school. That is called the 90% rule by a lot of people. If your child misses more than 9%, 10% of the school year or the semester, they have to get their attendance back over 90%. A lot of schools offer things like after-school tutoring, they offer detention, they offer Saturday school to help make up time. That is separate from parent contributing to non-attendance. So you could have both, but the non-attendance minimum school attendance requirement does not alleviate the parent contributing to non-attendance. But it may allow your child to make up time so they can get credit for their classes. But it does not excuse the unexcused absences if it is unexcused absences or parts of days that have caused your child to go under 90% school attendance. Based on the statute, if you go under 75% of school attendance, then there is no method for you to make up the time, therefore no method for your student to be able to get credit. So you want to discuss possible other options. Other options could be homeschooling, online schooling, or other forms of public education through charter schools. And so I would recommend that you get with your school officials and discuss what those other options may be. In a nutshell, I have provided you with, hopefully, will be an easier process to navigate so that you won't come to court and you'll be able to avoid having to go and deal with fines, possible parent or guardian ad litems, possible court-appointed attorneys, and possible court appearances. I would highly recommend, again, that you go visit with all of your local school officials if you have any questions or concerns in regards to their school board policy or Texas law on attendance. You're also welcome to come visit me by making an appointment by emailing any one of my clerks here in the court listed on the website. Thank you so much and good luck with this new school year.